Sonny, did you know you were going to be cross-examined today?
Yeah, I've seen law shows on TV.
Of course. Who hasn't?
Can I just say, watching law shows is not equivalent to understanding what happens in courtroom or in an arbitration. Because imagine watching this movie and being like, oh, I know how it works and I'm good. This video is light-hearted. We're Netflixing and chilling. We're going to be reacting to the movie The Arbitration. It's a Nigerian movie. It was released in 2016. You can find it up on Netflix. Some of your faves are in it, like Osi, Adesua, Somkele. So I'm excited to be reviewing this movie. I'm doing this because it has legal scenes. I think the whole movie is based on The Arbitration, which I spoke about in my last video. If you haven't seen that, be sure to check it out. I'm going to leave a link on the screen. If you don't find that, then it will be at the end of this video. Be sure to check it out. Let's get into the movie.
Your mom said to me that you were involved in commercial law.
We went to QC together. I told her I was a commercial lawyer, but she insisted.
Your client is very lucky to have you, in spite of your lack of experience.
So this is very funny because she's so polite, like her mom's friend, oh my god. But question about who represents you in arbitration, the fact is you can represent yourself, the company can represent itself. There is no requirement that you have to have a lawyer present, but you can have legal counsel or legal representation if you so choose. The Arbitration and Conciliation Act provides for this. It has rules in the schedule, and what that provides is that you can have legal representation, but you have to submit the names and the address of whoever is going to be representing you legally. Also, the comment about whether or not she's qualified. Any lawyer can represent you in an arbitration case. What is necessary is that you are comfortable with the lawyer and their level of expertise. If you want someone that is more qualified, there is a certification for Chartered Institute of Arbitrators, and so you can require that your lawyer has this, but it's not a necessity. A good lawyer would be able to handle your arbitration case. Okay, so they're in the room now. Parties are arriving.
Yes, I would like some more room, please. Look, I've had my fair share. I'd like some more room, so just make sure it's urgent. Have you confirmed the hotels? Yes. Yeah, absolutely. 3 seats.
See their faces.
Yeah, just confirm it and you can send them other details.
Why is he on the phone? This is not right.
Alright, good.
Finally.
Good morning. Good morning. My name is Tomisi Bokno. I am the arbitrator appointed by the chairman of the Chartered Institute of Arbitrators, Nigerian branch.
First things first, oh my god, so rude. Why is he on the phone? Usually, even for a basic meeting, think about it, there's some decorum and some courtesy extended to the parties involved, and so you would not just be on the phone when you can clearly see that everybody is ready to commence. So that's something to note. That usually wouldn't happen. The arbitrator's statement about being appointed by the chairman raises the question, who appoints an arbitrator? And simple answer is the parties should appoint the arbitrator in the arbitration clause in the agreement that has brought about this dispute. However, where they fail to do so, then the law says there'll be 3 arbitrators, and then one party chooses one, and then the 2 arbitrators choose a 3rd arbitrator, or the parties agree on who the 3rd arbitrator would be. For what he said, it means that there's a clause in the agreement that says that the chairman of the Chartered Institute of Arbitrators would elect the arbitrator. So it's not just random that you just throw it out there. You select your arbitrator in the clause. Section 6 of the Arbitration and Conciliation Act has the parties and appointing an arbitrator in it.
This arbitration shall be conducted in accordance with the Arbitration and Conciliation Act 2004. Farida, my paralegal, will take the minutes of this session. This is not a courtroom, but the rules of evidence may apply.
Arbitration and Conciliation Act of 1988, LFN 2004. That's Laws of the Federation of Nigeria 2004. It's not 2004 legislation, it's a 1988 legislation, so don't make that mistake. Don't talk about my paralegal. It's not necessary that he has a paralegal, but there should either be a recording of the proceedings that way can be transcribed for record purposes, or there's just someone that is administratively inclined that's going to help take notes of the meeting. And it's also not called minutes, it's called a transcript, okay? The rules of evidence do apply when it comes to arbitration. They are empowered under the Act to get evidence to ensure that the arbitral award at the end is fair and balanced.
May we take the claimant's statement?
I have a comment. The Federal High Court has ruled that this case must come to arbitration. However, I will challenge your jurisdiction to hear the matter.
The court has already ruled on this, Your Honor.
I am not a judge, Miss Oswald.
Not only has the court ruled on this, Mr. Buckner, neither the Court of Appeal nor the Supreme Court have agreed to take Mr. Sonny's appeal. It is clear that the arbitration panel is the right place for this case.
Miss Olujobi here had resigned her post at Iwaju Limited before this incident occurred. She therefore cannot be covered under the arbitration clause of her employment contract because that contract is void.
That is not true, Mr. Buckner. While Miss Olujobi had resigned, she was well within her 6-month notice period. She remained an employee. She earned a salary. As such, she should still be under the full protection of her employment contract.
Well, your comments are noted, Mrs. Johnson, but we'll go ahead.
Okay. I'm not even sure how to react to this. Like I've already said, the question of jurisdiction is raised via a plea by the party contesting it, and it is raised before the point of defense is filed, so it wouldn't really be raised at this point. Yes, the arbitrator can, like I said, decide its own jurisdiction, so hearing her out is a way, but it would not be done. It's not a comment. Okay, it's a plea raised. It should be documented. It should be filed. It won't just be orally brought up. That's not what the procedure is like. And he will definitely not just proceed without ruling on the contest. So what has happened here is there's been an oral exchange of the objection to jurisdiction, which is allowed, but the way it was done is not the way it is done, okay? You don't just push it aside. You don't just allow parties willy-nilly do it as they please. There's a formal procedure for how you would raise jurisdiction. So valid point raised about the arbitration clause. The issue there is that in the Arbitration and Conciliation Act, Section 12 has it stated in black and white that an arbitration clause will be treated as an arbitration agreement on its own. And so even if the tribunal finds that the contract itself is void, there is still going to be an arbitration clause, and it will be held as an agreement such that the arbitration tribunal would have jurisdiction. Do you understand? Because there's a clause that gives it powers, and that clause, despite the validity of the contract, is on its own an agreement and valid. So good point to raise, but the law already has the answer expressly stated. The Court of Appeal and the Supreme Court do not reject appeals. They just don't reject appeals, okay? Every appeal is heard. What can happen is your appeal can be dismissed at an early stage where a party raises the objection that the case cannot be appealed, or there's no substantive value to the appeal. So it's not that the court will just say by itself, oh, we're not taking your appeal. Fair hearing ensures that you have your day in court. So the question that also arises is, how is the proceedings going to be conducted? And the Arbitration and Conciliation Act has provisions in section 14 to 23 on how this should go. The general thing is that the arbitrator appointed or the arbitrators appointed will determine what the process and procedures are. As long as it's legal and is suitable to all the parties, it's fine. So from the scene also, the other thing that we would address is how arbitration proceedings start. It can start where there's a case in court already and one of the parties raises an objection that there is an arbitration clause in the contract that is being contested, or one of the parties sends a notice to the other party that they want to refer the case to arbitration. So either of these two ways is how the proceeding is going to start.
On the evening of August 10, 2015, my client, Ms. Dara Olujobi, visited the home of Mr. Benga Sani, the CEO of Iwaju Limited. Whilst there, she was sexually assaulted by Mr. Sani. The assault was the latest in a sequence that occurred over 2 years and created a hostile working environment for Ms. Olujobi. Mr. Sani's actions drove Ms. Olujobi out of Iwaju and cost her shares amounting to 30% of Iwaju Limited. Ms. Olujobi is seeking the accelerated grant of her 30% shareholding in Iwaju.
Usually, the parties would have documents, like I said, points of claim and point of defense, and in that they'll have stated their claim, they'll have stated the relief sought, they'll have stated all the evidence that they have. So it won't be that the lawyer will be recounting it and then the claimant here should be the one, so the documents be admitted by the claimant saying, oh yes, this is my claim, and yes, I agree that this is what I'm claiming, and then I want it to be before the tribunal. So it won't just be a recount, but I guess artistic license to ensure that we know what's in the papers.
You must be joking.
Mr. Buckner, please instruct the defendant to remain silent.
Again, this is not a courtroom, Ms. Oswald, and he is not a defendant.
Sure, in an arbitration tribunal, the formality is dialed down a lot, but there's still decorum expected of parties, so there shouldn't be back and forth comments like that, but it's, I guess, not something that you'll be sanctioned for.
Ms. Olujobi is also seeking damages amounting to the Naira equivalent of $1 million US.
Well, the purpose of this arbitration is to determine whether Ms. Olujobi should be granted her requests or not. To that end, we're going to take testimonies from Ms. Olujobi and Mr. Sonny. But if I'm unable to reach a decision after the testimonies, both parties will be free to bring in additional witnesses. Okay?
Interesting statement by the arbitrator. Things to note from his comments are that, one, witnesses are not called as an afterthought. Parties usually front load everything. Front loading means that everything is presented before time. So their arguments, their point of defense and claim, witnesses they want to call is written down so the other party knows what to expect. It doesn't seem fair if you think about it, that you're coming into the proceeding, you don't know what's going to happen. No, usually there's a, it's not a court, but there's some formality as to ensuring that the other party is well informed as to what you're coming to say and what your defense is or what your claim is. Imagine that we just came, you don't know what you're coming to answer to or what reply to give. It doesn't happen that way. You can't have a claim, and then not hear the defense, and with the defense, if you don't know what the claim is, how are you defending it? So they shouldn't even be here if they hadn't seen the statement of claim, and the list of people that are going to be called will already be for the tribunal, and the other party also would know. So there's an open process and some format and decorum and order to how things work. Now that we have in the points of claim, they're claiming that she is entitled to 30% of the company, some nice juicy cash. But the part I wanted to comment on is sexual assault. Now, this is a very, very big claim to make against a person. And like I said, I already made a video, you should check it out. There are things that cannot be arbitrated, and crimes are one of it. And in Nigeria, under the criminal code, penal code, sexual assault is a crime. This shouldn't be arbitrated on. This should be in a law court. So the basis of the case is something quite severe and grave. Although I understand trying to get damages, and which is why they want to come and enforce the contract, but it kind of is counterintuitive. You either are sticking to the civil side and not bringing up the assault as your major claim. So you're just saying that there was a breach of contract. So if sexual assault is the main claim, then this proceeding shouldn't be happening. But if it's breach of contract that they're trying to discuss, or some clause or terms in it that was breached, then that should be stated. So I'm slightly confused.
Question the claimant, Mrs. Johnson.
Do you mind if I stand? That was quite the story, Miss Olujobi. So did you go to the police?
Yes, I did.
What did
Raped.
Rape? Well, I don't mean to be mean, but what you just described doesn't...
Again, I had to pause this. Sexual assault is different from rape, so I'm not certain what they're claiming anymore. But suffice to say, if the police actually said that, that's so inappropriate, okay? One of the elements, I have a video up on rape on my channel. Check that out. Also, again, it will be somewhere on the screen. If it's not, I'll put the links at the end of this video so you can just click it and check it out. One of the elements of rape is that you are not married to this person, so you're not a spouse of the person you're claiming raped you. So the mistress of a man can be raped because she's not his spouse under Nigerian law, okay? So this is wrong premise. If the police actually said that, they were very, very wrong. And then again, how am I going to say this? Crimes cannot be arbitrated. What are we doing here?
sound like rape.
He had sex with me against my will. I think you'll find that meets the standard definition of rape.
What you described, Miss Olujobi, was an offer that you accepted, not rape.
He had my future in his hands. I couldn't say no.
We can do with a brief recess. We'll pick up Mr. Sonny's testimony in 30 minutes.
She definitely should counterclaim the offer and acceptance argument with the fact that it was without her consent. And so if there's some threat of some form, which she's saying that he threatened her with her job, it's a threat. It's fraudulently inducing a person to have sex with you. It does fall under one of the elements that need to be proved in a rape case.
See, you could have had sex with him a million times before, but all that matters is that the last time was coerced.
He's going to lie.
100%. You could have had sex a million times, 2 million times. All that matters is the last time there was no consent. You can be in the process of saying yes and change your mind, and you've said no expressly, and it becomes rape. So there is no argument that she was his mistress, they've been having sex. This comes up a lot in practice actually. And so yes, it's a defense that is raised, but it's also a defense that can be countered if you're sure that this person had sex with you against your will. Again, it's a crime and it should not be in arbitration. It should be before a law court.
Tell your client to drop the complaints. This is not the kind of case you want to lose. It's bad, very bad for your career.
I'm not selling out my client.
It's not selling out to act in your best interest or hers.
I love that face. Never ever sell out your client, okay? Never. Not for anything. It is against the rules of professional conduct to act in a way that affects your client's objective negatively. So definitely what she's offering is against the rules, and she really shouldn't be offering that. They're on recess, which is, allowed for the parties to breathe. There's a lot of tension. You want to settle it down. So it's good that they're taking a break. Just to note that it's not called a complaint, okay? It's an arbitration matter. It's not called a complaint. Complaints are taken to a police or a administrative body. A complaint is not laid before arbitration. What is happening is that your case is being taken based on the contract you have between each other and you're trying to resolve a dispute that has come out of that, it's not called a complaint.